Madam Secretary, if you don't mind, please calling the roll.
Senator Berg,
Present.
Senator Carroll, Senator Kerr, Senator Neal, Senator Schickel, Senator Schroeder, Senator Stivers, Senator Turner, Senator West, Senator Wheeler, Representative Banta, Representative Blanton,
Here.
Representative Bratcher,
Here.
Representative Cantrell, Representative Decker,
Present.
Representative Elliott, Representative Fisher,
Here.
Representative Hebron,
Present.
Representative Kulkarni,
Present.
Representative Lewis,
Here.
Representative Maddox,
Here.
Representative McCoy,
Here.
Representative Minter, Representative Mosier, Representative Nemus,
Here.
Representative Petrie,
Here.
Representative Scott, Representative Stevenson, Chairman Westerfield,
Here.
Chairman Mass.
Here.
Seeing that they have a quorum, I'm going to ask for a motion to approve the minutes from our last meeting. Motion and second made. All those in favor, please vote by saying aye. Aye. Those opposed, minutes are approved. All right, we do have some guests. I've got one. My chairman's got another one. I want to welcome Judge Joe Hendricks here to my right, here over in the crowd. I don't know why you drew the short straw today to come up here on behalf of the association, or maybe you're just here for fun, like the rest of us. I gotcha. Gotcha. Well, I appreciate it. Good to have you, Judge. Welcome. And Chairman?
I also have a guest, Wesley Schmidt, who's here with me today to my left. And Wesley is an intern in my office this summer. Will be heading to Columbia Law School this fall. So welcome, Wesley.
There's still time to change your mind, sir. All right. We are going to go out of order. So yesterday you all got an updated agenda. You see the third item there with the University of Louisville. I'm going to call them first. They were kind enough at the very last minute to provide a witness, and we've got Dean Tony Genzel, the Dean of the School of Medicine there at the University of Louisville, and she was very generous with her time to appear remotely this morning, and she's out of the country on vacation. And so I'm going to let her speak first, or go through this particular panel first, have her answer some questions here, and then we'll get on with the rest of the agenda. So with that, that's where we'll start. I'm going to welcome you. Is it Dr. Genzel or Dean Genzel? I don't know which title you prefer.
Either one. It's Tony Gansel. And I would like to say that I'm not out of the country. I'm out of the state, but I'm in Nebraska, so I'm still in the country.
Well, then you're welcome. I appreciate you making time because you didn't have to, and I let university folks know that it didn't have to be somebody out of pocket, but I appreciate you doing that all the same. I put you all on the agenda. I put the university on, and I appreciate you coming because of what I heard in court yesterday, and I guess it differs from what my understanding was in the past. And so I know members have questions, and I've got questions about the relationship that University of Louisville has with EMW Clinic, contractually, financially, and that's what I'd like to clear up. Because again, what I heard yesterday in court is not consistent with what I and other members of this legislature have been told by the university and its leadership in the past. And so I guess I want you to tell us what that relationship is. It was described yesterday in court as a joint venture. I'm going to know what that's about.
All right. Well, thank you so much for the opportunity to appear before the committee this morning. We at the University of Louisville greatly appreciate the support of our General Assembly and really, really value your interest in our programs. So I'm happy to answer any questions that you may have for me to do today. But before I do, I'd like to provide a statement that I hope maybe will clarify the university's policies and perhaps address some of your concerns. It's important to note that the university does not perform elective abortions at the U of L hospital or any U of L health facility. No university funds are spent on abortions. We have and will continue to comply with all of the applicable laws of the Commonwealth and federal laws. As required by our Residency Accreditation Council, the Accreditation Council for Graduate Medical Education, or ACGME, we do provide training or access to training in the provision of abortions as part of our OBGYN residency, just as every program in the country does. This training is conducted at a non-university facility and is required of all OBGYN residency programs, including ours at the University of Louisville and those at the University of Kentucky. Since March of 2016, the university has had a departmental support agreement with EMW Women's Surgical Center. This is not a joint venture. Through this agreement, EMW does provide some annual salary support for 2 physicians in the U of L School of Medicine's Department of OBGYN and Women's Health, and the contributions support the residency program and allow residents to complete the training requirements mandated by the Residency Accreditation Program. If we did not provide this training, our OBGYN residents would have to leave the state to receive it. Residents do have the opportunity to opt out of participating in this procedural training that's required by the ACGME, and they have the option of receiving this training through computer modules or other offsite alternatives if desired. So I'm happy to take your questions, and I will answer those to the best of my ability and provide you with any additional information that you may need.
Thank you so much, Dean. Representative Nemes.
Thank you, Mr. Chairman. Dean, I appreciate you coming at such short notice. I want to say that I think most people in the General Assembly were very proud of U of L, very proud of University of Louisville Hospital, and we were happy to do what we were told was to give some existential money for University of Louisville Hospital a couple years ago at the request of President Neely Bendapudi. I have been a big supporter of U of L, a defender of U of L, and will remain so. I do have some concerns because the information that I've been given and the information that you just stated there is not in line with what testimony has been given by Dr. Bergen, both in 2018 deposition, which I have read, and yesterday in court, in which I was present in the courtroom. Both of those times she was under oath. She said that in 2018 it was a joint endeavor of U of L and EMW. Yesterday she said it was a joint venture. Understand we have a department support agreement. We'll have some follow-up questions about that. She also said when she was hired, it was her job responsibility and expectations, and remain so today, that she will perform abortions at EMW, not just for training purposes, but she will perform abortions as part of the University of Louisville's family planning responsibilities. She also mentioned that she is there now currently 2 to 3 days per week. That's her job location, 2 to 3 days per week. Many of those days residents are not present. She testified that she performs between 1,200 and 1,400 abortions per year. As a university employee, she is not, she said, an employee of EMW. She's an employee of the University of Louisville. She says she's paid by U of L. The only time that she receives payment from EMW is when she takes night calls or weekend calls. But the 2 to 3 days a week that she's performing abortions, she's doing it on behalf of the University of Louisville. On her CV, she does not include EMW as an employer because she said she is not employed by EMW. She is not a staff member of EMW. And so these things are in stark contrast to what the University of Louisville has told us. I reached out to the president of the University of Louisville a couple years ago when these allegations came to light and was told that she is misinformed, that she is not telling the truth or misunderstands what she's saying in the 2018 deposition. I've defended U of L among my colleagues in the public based on the information that I was given. That information is in question now. So I want to know the 2 to 3 days a week that Dr. Bergen is performing abortions, is that as a U of L employee? Is she paid by U of L to perform abortions as she says that she is?
She is not paid by U of L to do abortions. She receives salary support. The department receives salary support for her to train residents in the required mandated accreditation standards. But she, in her job description for the University of with the University of Louisville, there is no mention of her providing of her performing abortions as a requirement for her job at U of L.
I would like to request, and Mr. Chairman, I'm going to ask these documents in writing after the meeting, but I would like to request the dollars that EMW provides, not only for Dr. Bergen, but for the other University of Louisville physician who performs abortions, an equal number of abortions at the EMW clinic, giving us about 2,500 to 3,000 abortions that are performed by U of L employees. So if there's a botched abortion and someone files a lawsuit, I'd also want to know, does University of Louisville's insurance policy cover that? Or would that be EMW's policy?
I will find that out. I would think it would be EMW's.
Okay, so if EMW provides a salary to University of Louisville for a salary supplement, is the taxpayer-funded pension and 401k contribution that comes from U of L, is that based off of full employment status? Because if she's at EMW 2 to 3 days a week, and her testimony was only some of those days University of Louisville and University of Kentucky residents are present, but most of those days they're not. Is she classified as a full-time public employee, thereby getting paid by the taxpayer to, I don't know how you can say or get around it, to perform abortions? I also want I'd like to have the employment agreement, because her testimony yesterday was very clear, and it was right in line with what she said in 2018, that she was hired in 2015, and the expectations remain the same. She was hired to perform abortions at the EMW clinic, not a mention of residents. And so whether you're for abortion, against abortion, whatever, it doesn't matter. We need the facts here, because she's testifying now twice under oath, something that is markedly different from what the president of the university has told us and now what the head of the medical school has told us. And so the information it differs, and we have to get clarification on that. I've got a lot of other questions, Mr. Chairman. I don't want to monopolize the time. If I might, if we could get our friend to commit to respond to written questions and to also supply documents that we request.
We absolutely will. We'll work with Shannon Rickett to do that.
Thank you. Thank you, Doctor, for showing up. Thank you, Mr. Chairman.
Thank you. I do have Senator Berg.
Thank you, Mr. Chairman. Thank you, Dr. Gansel, for being here this morning. Very much appreciate you making the time. I think I'm going to take a minute to explain something and then ask a question. While there may be significant differences in opinion among the elected legislators on this podium, the standard course of care in the United States of America requires us to train our OBG residents in how to perform all sorts of procedures, some of which may be needed on an emergency basis as they go forward with their patient care. So when you all are up here saying, by default, that the University of Louisville should not be training their OBGYN residents in this regards, the truth is, it is a requirement for certification of the program. That is not a political decision. That is a medical decision, because there are times, whether or not you believe that elective abortion is moral or amoral, that we have surgeons who need to have these skills. It is a requirement for them to have these skills. And push comes to shove, people on this committee, there are times when you are going to desperately want your OBGYN surgeons to have these skills, because it can be a matter of life and death. We do not perform elective abortions at the University of Louisville. We do have a program and a departmental support to train them It is a requirement for the residency. It is a requirement for the certification of the residency. Now, as far as salary, staff support, I'm not sure you understand how physicians at the University of Louisville typically are paid. It is a combination of support from U of L and then the private practices that bring in money. So most of her salary, and I don't know what her salary is, I don't know how much is U of L, how much is ULP, how much is outside, but most of her salary.
Well, let's ask the doctor that, if she knows.
I don't know exactly how her salary is split. My understanding is that the work assignment that involves her time at EMW, that salary is supported by EMW through the departmental support agreement. But again, we'll get those detailed contracts for you.
Senator Berg, Dr. Berg, Senator Berg, whichever title you prefer.
Like Dr. Gansel, it's Ken.
That's right. It's tricky. I thought after.
Let me continue, sir, please.
If you've got a question, let's go ahead.
I do have a question. What would happen to the departmental accreditation if you didn't fill these requirements for your residencies?
We are required to, so it would go on probation.
And then eventually, if you didn't fix that, would you lose your program?
Yes, we would.
So it is an absolute requirement
It is
that
an
these
absolute
residents are taught. And let me just one more thing for clarification, because I teach residents every day, and part of my salary support goes to teaching residents, okay? If there's not a resident in the room, it is still my job to do the work. It is 100% my job to do the work. I don't care if there's a resident available that day or not. And due to their schedules and their learning and what they're required to do, they may or may not be sitting next to me. It is still 100% my job as the attending to complete the work, because these are real live patients with real live needs. Part of my job is to teach the residents. It's a part of my job that I love. But ultimately, my responsibility is to the patients. And so for her to be working without a resident in the room is what she's supposed to be doing. Thank you.
Mr. Chairman, may I
Yeah.
be acknowledged?
Go ahead, Representative
Thank you.
Davis.
I want to be very clear about what we're talking about here. My friend, Senator Berg, has, and she is my friend, has, Senator, I didn't mean to promote you, Representative Senator. my friend Senator Berg has misstated some things here. We are not in any circumstances talking about whether or not U of L has a responsibility, and UK for that matter. I know they send their students to the University of Louisville for this kind of training that's required, that I'm told is required for accreditation. We're not talking about that. What I'm talking about, and I was defending U of L for years on that basis. What I'm talking about is the sworn testimony from Dr. Bergen twice now, where she says it's her job responsibility, not for residents, not in connection with the residency program, but it's her job responsibility to perform abortions for the University of Louisville's family planning services. If that's U of L's position and what they do, we need to know about that, and the facts will lead where they lead. But that's very different. So we're not talking about the training program and trying to say that's not, it is or it is not required. That's not what we're saying. So we need to be clear on that. What we're saying is this. What I'm asking is this. Dr. Bergen testified that she was hired to do these things aside from, apart from the residency program, and that she does them 2 to 3 days a week, every week. Some of those weeks, the residents aren't even in school. She said 6 to 8 months they're in school, and even when they're in school, many of the days they're not there. That's not doing the work for the training of the residency program, it seems to me. It may or may not be appropriate, but I don't think the overwhelming number of, I believe the overwhelming number of taxpayers in Kentucky do not want their money and their institutions and their government, which is what University of Louisville is, going toward performing abortions. So if that's what the university does, and if they pay that, you said, no university funds are used for abortions. That, in my mind, is in question. So I want to know, and we'll have these follow-up questions. I want to know, is any of her time at EMW that is not connected with a resident paid for by U of L? If it is, then there is clear misstatements here. And it seems to me that there were misstatements in 2018. I was told by the president's office there was, and she doubled down on them yesterday. I not only am trying to do this right for the taxpayers of Kentucky, my integrity is in question. Because when my colleagues have come to me in the last 2 years and said, U of L's done this, I have parroted what you've just said. That is now, in my mind, wrong. And so my integrity is in question. I've called out organizations who said, U of L's done this. And I said, no, don't you say that about my university. U of L does not do this. It seems to me that I have been wrong. And so we're going to get the facts out straight. But to be clear again, this is not about, contrary to what my friend Senator Berg said, this is not about undermining the training program or questioning whether having abortion services in that context are required. I accept that they are. I don't quibble with that. What I'm saying is, outside of that, if the university funds are used for abortion, $1,200 to $1,400 a year, one employee, maybe the other one as well, doing it 2 to 3 days a week at the MW clinic, that's something that the taxpayers ought to know. And the legislature should take that into account when we're talking about funding the university and doing other things. That's what I'm saying. It's very different from what Senator Berg represented. Thank you, Mr. Chairman.
Dean, I appreciate your time. We might submit in writing questions to you and Shannon there for the university to provide. I'd like to see if you could provide those contractual agreements that you have with EMW, especially if not in those contracts, then if there are separate agreements that handle the financing aspect of that. I agree with everything that Representative Nemes has just said, because what we've heard today is not consistent with what we heard under sworn testimony yesterday in court, and that's a problem. So it's a problem for us. It's a problem for the university, I would think.
Understood. And I've not seen the details of the testimony yesterday, and I will review that. But based on what you're saying, the statement is inconsistent with my understanding.
Yes, ma'am. Again, I think it's in your best interest, it's in our best interest, and certainly in the best interest of taxpayers that I agree with Representative Nemes, the majority of whom probably don't want their tax dollars going to that, to clear this up, to understand exactly where the dollars are going and who's getting what and what the relationships are. Another question was raised, a member here shared a text, whether or not University of Louisville's workers' comp extends to activities at EMW. The liability coverage question is an open question. That you believe it was EMW? Let's see what those coverage policies say, and if there are limitations or restrictions on that. I think we need to get to the bottom of that, because it's been kicked around in different ways, and we don't have a consistent answer from either employees or administrators at the university, and that needs to be corrected. So I appreciate it.
Certainly.
Thank you so much for giving us your time, especially when you're out of state. I appreciate it, and we'll let you go. Have a great day and enjoy the Cornhusker State.
Thank you.
All right. Thank you all. I'm going to call up our group here on charitable bail. Is Representative Blanton here? You want to go first, sir? Or you want to respond? Yes, sir. All right. Then I'll welcome up Shamika Parrish-Wright and Carrie Cole with the Bail Project there in Louisville. Ladies, good to have you this morning. Appreciate your time. Thank you for your patience as we went a little bit out of order there. You all have the floor. Yeah, make sure that mic is green.
We are more green now.
More green.
Okay.
There we go.
Sorry about that. All righty. Thank you very much, Chairman Westerfield, Chairman Massey, and members of the Joint Committee for inviting us to testify before you today. My name is Carrie Cole, and I'm the Operations Manager for the Bail Project Louisville site. I grew up in Louisville and work here. This is my home. I'm joined by Shamika Parrish-Wright, our Partnerships and Advocacy Manager. We come before you today to speak about the Bail Project's recent and ongoing work helping Kentuckians who are in need of bail assistance while advocating for improvements to the pretrial system. The state of Kentucky has been at the forefront of critical reform to improve the pretrial system. When the General Assembly outlawed the operation of the for-profit bail bonds industry in 1976, Kentucky stood out across the nation as one of the few states willing to eliminate a predatory industry that profited from the poverty and desperation of Kentuckians who can't afford bail. Recognizing that no one should be earning money from an individual's justice system involvement, Kentucky took crucial steps towards reforming the pretrial system and minimizing the harms and inequality imposed by a cash bail system. We applaud this legislator for its dedication to the improvement of the pretrial system, and we share that aim. In the previous legislative session, the General Assembly considered House Bill 313 and Senate Bill 313, bills that would amend these prohibitions on the for-profit bail bonds industry to include prohibitions on charitable bail organizations like the Bail Project. We appeared before the House Judiciary Committee to make our case as to why that was a step in the wrong direction, and we come before you today not only to continue to argue against restrictions in our work of charitable organizations like the Bail Project, who support some of Kentucky's neediest, but also to help bring more context to the work we do and the how and why we do it. While it may seem that the services provided by an organization like the Bail Project are similar to a bail bondsman, we couldn't be more different. Our interventions differ significantly, both in our service model and in our reasoning for operating. The Bail Project is a nonprofit organization, and our services are 100% free. Through our National Revolving Bail Fund, which is powered by individual donations, we pay bail for low-income individuals who are legally presumed innocent and whom a judge has deemed eligible for release from jail contingent upon paying bail. After release, we connect our clients to voluntary social services and community resources as needed. And by doing this, we enable our clients to return home to their families and their communities while awaiting their court dates. As our clients resolve their cases, bail is repaid and recycled so that we're able to help additional people. While the Bail Project operates nationally, we put our roots down in the communities that we serve. We've been operating in Louisville and 28 other Kentucky counties since 2018, and in that time, we have provided bail assistance to nearly 4,000 Kentuckians who have returned to over 90% of their court dates without incident. The Louisville team has provided court notifications and other supports for over 14,000 court appearances, helping people get their day in court. Freedom makes all the difference. Of those whose cases have closed, only 10% have had to spend additional time in jail as part of their sentence. Through our work, our staff has gone into jails across the state and country and met with thousands of people trapped by bail. By our estimates, our work in Kentucky prevents, on average, 51 days of jail time per person. Across our nearly 4,000 clients in Kentucky, this amounts to over 200,000 additional jail days served. By preventing the unnecessary incarceration that results from wealth-based detention, we estimate that the Bail Project services have saved Kentucky's taxpayers approximately $15.3 million since 2018 by reducing the costs of jail administration across the state. Like charities and faith-based groups, we provide our services free of charge to help poor Kentuckians who would otherwise remain incarcerated simply because they cannot afford the bail that the judge has set as contingent for their release. We intervene when individuals, their families, and their communities do not have the necessary financial resources available to provide for their loved ones released from jail. Our services, unlike the for-profit industry, does not profit off of individuals in any way. Additionally, through our model, we partner with local social service providers to offer voluntary referrals to critical post-release supportive services that are not otherwise available to people when they are released on their own recognizance or when a family member posts their bail. These critical services, which are coordinated and facilitated by Bail Project staff, meet many of the unmet needs that affect people throughout our state. We provide court reminders and travel assistance. We assess individuals' needs and make voluntary referrals to substance use treatment and mental health service providers where those providers exist in the community. When people are housing insecure, we work to identify temporary or supportive housing for them where those organizations exist in the community. And when people need help finding a job, we provide them with access to community-based services that offer employment and education services where possible. This holistic service model was something never provided by the for-profit bail bondsman. Furthermore, our community release with support model is something that, if provided by the court or the state itself, is generally small in scope and less tailored. The Bail Project is one of the few charitable organizations that exists here in Kentucky to provide voluntary referrals and wraparound services to people who are released pretrial. Without our services, when people are released from jail, they are rarely able to navigate their way to social service providers that would be most helpful to them, because we know that the social service system is too complex. So we designed our program so that we were able to make those referrals for them. Our experience demonstrates that simple measures like text and phone call reminders about court, transportation assistance to and from court, and providing problem solving around childcare, for example, substantially improve appearance rates. Sometimes all that is needed is a conversation to talk through a plan to get to court. All of this increases the likelihood that they will successfully navigate the pretrial period of their case without incident, and more importantly, that they will finally be able to receive care and support to address some of their lingering and persistent difficulties. All of our services mean that individuals who would otherwise remain incarcerated simply because they cannot afford bail are able to leave the jail, return to their families, their children, their jobs, and their communities. Taken together, we are starting to see that this decreases their likelihood of becoming justice evolved again in the future. Community members, we are all community members, but committee members, sorry. The Bail Project work prevents the unnecessary disruption and harm that is caused by a period of incarceration. By intervening on behalf of the Kentuckians who are otherwise too poor to pay bail for themselves, we decrease the chances that someone will lose their job, lose their homes, or be separated from their children and exposed to traumatic and criminogenic effects of incarceration. Again, we offer these services charitably and completely free of charge. Unlike bail bond companies, who work with anyone who can afford the 10% premium to access their services, we evaluate each referral on a case-by-case basis and make our decisions based on an assessment of need and our own ability to provide support for our clients upon release. Our screening criteria is rigorous, which makes us different from for-profit bail bonds companies, or even just a friend or a family member who wants to carry out their legally permissible right to pay bail for someone. We look at the larger context of a person's criminal justice involvement. We administer an intake questionnaire to identify unmet needs. We refer people to services. And when necessary, we elevate cases to a higher level of managerial scrutiny and oversight. We do all of this because we do recognize that these are complex decisions and not business transactions. I know I've been speaking in general and wonky terms about our work, but really at the heart of the Bail Project is our commitment to our clients, the thousands of people who we've had the honor of meeting and serving as we've expanded the Bail Project across the country. One of our clients from Louisville, Alicia, who received our bail assistance, said, "Since my release, I have started my own construction company. I've also been accepted into 2 business accelerator programs. I'm doing well, providing for my family while attending court dates as required to fight my case and take responsibility. I've attended every court date with the help of court reminders and transportation from the Bail Project, and I am thankful for the work that they do." Personally, as a social worker by training, I deeply understand the social challenges that your constituents face. Firsthand, I've worked with people struggling with substance use disorders and mental health illnesses who can't seem to find their way to effective treatment. I've worked with single mothers and single fathers and families throughout the state that have struggled to find employment, to keep food on the table, and keep the lights on. I've worked with people who have lost their homes and couldn't afford rent and lived on the street. The problems we face in Kentucky, we face together. That's why I joined the Bail Project, and that's why I'm here today. The Bail Project's work as a charitable bail organization provides an essential service, not that dissimilar from a food pantry, and Kentuckians cannot afford to lose access to our services while the bail system exists in its current form. We have a crisis of mass incarceration in the state and in the country. Sometimes we at the Bail Project are the only lifeline available to someone who is too poor to afford bail that is set for them. Thank you for providing me the opportunity to testify before you today, and I want to give Ms. Shamika Parrish-Wright an opportunity to provide her written remarks.
Thank you, Carrie. Thank you all very much. Chairman Westerfield, Chairman Massey, and members of the Joint Committee for inviting me to testify before the Joint Committee of the Kentucky General Assembly. My name is Shamika Parrish-Wright, and I am the Partnerships and Advocacy Manager for the Bail Project. I have lived and worked in Kentucky for more than 20 years. I am a constituent. I am a Louisville resident. This is my home. The issue of bail is close to my heart because I have suffered from it personally. When I was 18 years old, I was getting ready to start college, and I got engaged. That's young love for you.
One night after we had hosted a birthday party for my brother, my then fiance became very aggressive. I was cleaning up while speaking with the lady who lived in the neighborhood. She had brought some cleaning supplies to help me, and I offered her a drink and thanked her. He did not like this. He smacked the drink out of my hand and began yelling at me. So we had an argument. It was my home, and I told him to leave. I began to pack his belongings, and before I knew it, he was all over me, punching me and kicking me. I thought he was going to kill me. I tried to defend myself any way I could, grabbing onto objects as he threw me around, and I was yelling for help. During the commotion, a neighbor called the police, and they arrived shortly after. When the police came, I told them everything that had happened. I even wrote it all down. I had never been arrested, and I did not realize that I was signing my own warrant. I was handcuffed and taken to jail. I spent 2 days in jail before I ever saw a judge. Little did I know my ordeal was just starting. My ex-fiancé, on the other hand, who was charged with domestic violence, was able to quickly secure his release because he had resources to do so. Even when he came to court to defend me and explained that he had started the altercation, the judge did not care and set my bail at $10,000. I didn't have the money, and neither did any of my loved ones. I was charged with a felony and was told that I was facing prison if I went to trial and lost. I didn't know what to do. I had a young daughter at home and my college education ahead of me. I saw my life falling apart before my very eyes. Like so many in that situation, I had to weigh my options. Do I plead guilty for a lesser offense and go home to my daughter and start college on time? Or do I hold on to my innocence and sit in jail until I can have a trial? After spending 38 days in jail, I pled guilty to a lesser charge. All I wanted was to get out, to be with my daughter, and to go home. I knew this plea would give me a criminal record and that would follow me for the rest of my life. Until this day, you run my fingerprints and that's what comes up. But at that moment, I felt I had no other choice. And that's the choice countless people make in Kentucky every single day because of the cash bail system. If I had had the money to pay my bail, if there was a charitable bail organization like the Bail Project available to support me, I could have gone home, worked with a lawyer, fought my case, and I could have avoided conviction. I would not have had a criminal record, but because I was poor, I did not get my due process. The presumption of innocence only existed on paper. Cash bail rests on a common misconception that the only way to secure an individual's return to jail is to require collateral from them. When cash bail is used, the vast majority of people detained pretrial remain incarcerated solely because they lack the financial means to pay bail. Most Kentuckians cannot afford a $1,000 bail or a $1,000 emergency expense, let alone that bail is on an average often set at twice the amount that anyone can afford. This creates a two-tiered system where those who can afford to pay bail are released and those who cannot remain incarcerated. This two-tier system criminalizes poverty. It is also one of the key drivers of mass incarceration, which is an American epidemic. Half of the American adult population have at least one family member who has been incarcerated. And here in Kentucky, people in pretrial detention now make up more than half of the state's total jail population. More than half. Across the state, a substantial number of Kentuckians, people like me, remain incarcerated because they cannot afford the bail amount that is set against them. We've paid bails as low as $25 where someone sat in jail for over a month. $200, $500 for someone accused of stealing a can of baby formula. So she didn't have the $30 to pay for that formula. She definitely doesn't have the $500. The human toll of cash bail is catastrophic, levied almost exclusively on the poor and disproportionately on communities of color. People who are jailed pretrial often wait months and sometimes years for their cases to resolve. In the meantime, they can lose their jobs, their homes, their children, and critical community ties. Inside jail, people are at risk for sexual violence, the deterioration of their mental and physical health, and the infliction of lasting trauma. They feel enormous pressure to accept an unjust or wrongful conviction just to go home. And as with all other areas in the criminal legal system, people of color bear a far heavier burden due to an enduring legacy of racism and economic disenfranchisement. And the financial costs that this system generates are staggering. The average cost to Kentucky's localities for just 1 day of incarceration is at least $77 per person, an amount that climbs far upward if the person requires medical or mental health services. In the fiscal year of 2019, the year of the most recent available data, the cost of Kentucky's counties of incarcerating only those individuals charged with felonies was approximately $141 million. As we have scaled our program of free bail assistance in the 28 counties across the state, we have received calls, had many meetings from community stakeholders requesting that we expand our services even further. These are former judges, current attorneys, community leaders, faith leaders who are asking us to come to all parts of Kentucky. But at the time, we have also seen this esteemed body introduce legislation that seeks to limit the effectiveness of our services. Any regulatory effort that pursues these aims will only harm the Kentuckians who benefit from our services. Even with our current services, there remains a tremendous service gap in care coordination and support for people who are released pre-trial. So if you regulate us, who will provide these critical care coordination services? No other organization is doing this across our state, and especially as a nonprofit. How will you ensure that the cash bail is set according to someone's ability to pay and not used as a form of wealth-based detention? Where do you stop? Can nonprofits not pay bail? Can a church not pay bail? These are important and difficult questions. Once bail is set by a judge, we do not set the bail. A judge sets that bail. It should not matter who pays it. Poverty knows no bounds, and I know that personally. It is not defined by geography. It affects people across our state. And we are grateful to Representative Blanton for his willingness to be a partner with us to address and tackle the challenges faced by justice-involved people across the state. The urgency of our concerns must focus on the elimination of cash bail and the reform of the pretrial system altogether. The previous legislation does not deal with that. Something the Bail Project is experienced in is developing a model of robust pretrial services and supports that can be adopted across this country. The Bail Project's intervention is designed to enhance public safety of the communities in which we operate. We care about public safety, and we do not want to undermine it. And we are doing that. We have the experience, we know what works, and we urge you to work with us instead of against us to fix the problem. Do not eliminate or restrict our ability to operate. Work with us, partner with us, so that we together can end wealth-based detention and develop a comprehensive pretrial system that Kentuckians need to support pretrial. We want to support the people. We'd welcome any of you to visit us in Louisville. We want you all to make sure that this is the best program of its kind. Thank you for your time.
Thank you both so much. I do have a couple of questions, and then we've got some members that have questions. Ms. Cole, you mentioned that there were savings to the court system, but I'm wondering what data you're basing that figure on. It was $15 million or something like that.
Yeah, absolutely. So the AOC does gather this data, and we always are able to request data from them.
Sure.
And during the General Assembly, or during the legislative session last session, the LRC also did some data collection and looked at cost and finance. I'd be glad to provide that data to you after this.
But the figure should depend on how long people were in custody. So you're making some assumptions on averages, I assume?
Right. And if we could look at actual, data, if the state was able to collect that data, we would love to provide that, look at it, and operate in that clarity. But we are having to make assumptions because there is a gap of data collection within the state. But like I said, I'd be glad to give you the data that we did pull that from.
Well, I think you'd have to act on assumed levels or lengths of stay, because you're talking about people who aren't in custody anymore. You're having to make assumptions about how long they might otherwise have stayed had you not bailed them out, right?
Mm-hmm.
Well, we do know from our data, because as Carrie is speaking about, there's gaps in the data all over our state, and we all know that. There's things that are being collected. There's other variables that determine how long someone is in there. Based on what the jail told us, $80 a day, average stay of being 23 days, we've seen that cost is also impacted by that. But also our data shows that we've invested over $12 million to bail out nearly 4,000 people. And so we know that money directly saved the localities, because that's money that they would have been spending to take care of the people in there. But you are correct. But the problem is there is a problem accessing the data so that it's accurate. And that's why we are here today, so that we can work together. We don't want to be doing this 5 years from now. We want to work ourselves out of a job. And we cannot do that without meaningful bail reform. What has been proposed does not deal with the data gaps, and it does not deal with these other inequities.
Are there charges that the bail project won't consider?
So whenever we do take a referral, we want to look at the full context. So we want to look at bail amount. We want to look at the current charge. We want to look at someone's ability to appear in court, their past ability to appear in court. So there's multiple factors that we take into consideration before we make that bailout. So charge is only one piece of that. And there's not, I can't give you a blanket statement of these are ones that we won't, these are ones that we will, because in pretrial.
Sorry to interrupt, is there a policy that says, regardless of any other factors, anybody with X charge or offense is a disqualifying event for us?
No, because everyone is presumed innocent
That's
in
right.
pretrial.
And understanding that we are a nonprofit charity operating with limited funds of people who donated so we can get people out. Most cases won't come across our desk if they're $250,000 above, or we don't get those kind of referrals. Our referrals generally focus on people who are stuck in poverty and who can't get out, and they're usually lower level offenses. But people, it's just what got them into jail, they're going back out to, so each case is complicated. So we deal with it on a case-by-case basis, and we get those through referrals from the community, from our public defenders, and from advocates all over the community.
I was going to ask that question too. How are you finding out about which cases? Is it solely based on those referrals?
Referrals, people go to our website,
Sure.
and because we've been doing it now for 4.5 years, more people know about our work, and so they request. We've even had people in elected positions who have reached out to us. We've even been referred police officers, corrections officers, the children of judges and lawyers. So this issue of bail impacts so many people, and just as I gave the example of someone being held for $25 for over a month, any amount is unaffordable if a person doesn't have it and their family can't support it.
I agree with that completely. What is the average bail amount, at least in Kentucky, that you've provided?
Again, it varies. We do have...
I'm just asking for the average.
And I'm happy to answer that. We have a soft cap internally that we do operate out of, but that is dependent upon location, need, and things like that. Like I said, bail amount is one factor that we do take into consideration, but I can't give you a black and white number because we look at everything at a case-by-case basis.
But there's an average, and I'd like to know it.
The average of what we pay or the average of state across Kentucky?
Just Kentucky. What is the average bail amount you're offering or that you're providing? If you were to take the highest, the low,
I know what an average is.
Okay.
I'd be happy to give you that information. I'll have our team reach it back out to you and provide that information to you.
I appreciate that. Please do that, because the bill that Representative Blanton's filed and that others have worked on and that have been considered by both chambers and that were debated even in the Senate, though the bill, as you all know, didn't come forward, because there's some question about where a threshold should be if you were to set a threshold, a cap, so to speak.
So the threshold, sir, I just want to make sure we're clear. You had a state rep that had a charge that will be considered domestic and violent, had a $25,000 bill and was able to pay that in under an hour. And so to read the bail amount is not as significant as we've seen. People with money, if you have enough money, it doesn't matter what the bail amount is, you can get out. But for us as a nonprofit, like I said, we are responsible stewards of people who donate to our organization to help as many people as we can. That's why we wanted to be here, because what is being proposed will not stop that state rep. Right, it will stop the people who are really struggling, who don't have a grandmother or a grandfather or the education or anything that would help them get out of jail.
You mentioned, and you're right, that if there were prohibitions in place, that it would stop a church group or name some other organization, whether or not it's organized like the Bail Project or not. Are you familiar with any that you could name? I'm not going to ask you to name it, but are you aware of any such organization in Kentucky that isn't the Bail Project but does what you do?
Churches have been bailing people out, the choir member's son, gathering money, and actually this legislation won't stop people from doing that.
I'm sorry to interrupt, but I'm going somewhere with the question.
Okay.
So the answer to that question is a yes.
Yes.
You can think, all right. The one that you're thinking of, pick one in your mind. Do they go through as rigorous a process to determine whether or not someone should get that help as you do?
Excellent question. No. If you are my brother and you call me and you're in trouble, I will be there to bail you out. Sure. I'm not asking many questions. I'm showing up and say, get him out of there.
That's right. That's right. I appreciate your candor and your response there. I think that's accurate. One of my concerns, I don't disagree with the concern about money bail. I don't disagree with the fact that I think there's a constitutional issue there, that if you're poor, any amount of bail could effectively mean you don't get it. You're not out. There's no means of release short of some sort of help like this. But I wonder if you share the concern that as these groups proliferate, and 10 years ago you didn't exist, these groups weren't around, I wasn't aware of any that did this sort of thing. Maybe there were somewhere. We weren't talking about it. And there are more today than there were a year ago or 2 years ago. Isn't there a risk that this could cause bail values to keep inching up around the state?
That risk is there, no matter if we're doing this work or not. And 10 years ago...
Well, I disagree with that, because I think without you all there, you've got the discretion of judges, which, with all due respect to Judge Hendricks, sometimes judges get it right and sometimes judges don't get it so right, unlike the legislature, which clearly always gets it right. You've got discretion that could be exercised in different ways, but I'm concerned about if judges continue to know, in particular as this moves out of the bigger cities and into rural Kentucky. I can honestly and very easily imagine judges increasing bail values because they don't want someone that's unrelated to the court to come in and bail someone out that they want to keep in, that they believe is a safety risk to the public or a flight risk. And regardless of what your analysis might be, and so it could end up hurting those that don't get to benefit from your services even more. Is that not a risk?
I mean, that's why we're here. It is hurting people who don't get the benefit. The example I gave about the state representative, that none of this deals with that. None of this deals with the fact that somebody with money can go out and do anything they want and more than likely get out. But as you talk about, as it relates to money and judges, judges do have judicial discretion. They have 6 other options they can impose as release conditions. And our system has in place that if there's clear and convincing evidence that someone poses a threat, the judge has that judicial discretion to do what they need to do. The issue is that most people that we bail out, over 94% of people we bail out do not go on to prison. More, they come back to court. So we should not legislate based off a few one-offs. Yes, those are tragic.
I agree with that.
And yes, we will do what we can to do our part and be responsible. But a judge has the most all-seeing view of anybody's criminal legal history. We don't, as a nonprofit, and like I said, if you were my brother and I'm your sister, I'm going to bail you out. I don't know all your history, not necessarily, and I don't have that at that moment that I pay your bail, but a judge does. So we come in after a judge has made that decision. That's when we come in, never before. And once we come in, we have a constitution, we have all kinds of legalities in the judicial process, even civil processes that deals with other issues as they arise.
Regarding the bail project, are Kentucky dollars used only for Kentucky bail?
If you donate, and I hope you will, if you go to bailproject.org and you donate online, you can choose if you want that to go to the general organization or to Kentucky. But yes, we have both. Okay,
so it's not just universally limited for Kentucky dollars. So Texas dollars could be used to bail people out in Kentucky.
I
Or
don't see
Kentucky
Texas
dollars
helping
could
us.
be used to bail out some people in Nebraska.
If you donate to the March of Dimes and you want to
I'm
dedicate,
not asking about
it's
the
the
March of
same
Dimes.
way, sir. If someone wants to restrict their money for Kentucky, they can. But I haven't never seen in the 4.5 years that somebody from Texas says, I want to do this just for Kentucky. Most of the people who support our work live within the state, or they donate to a pot of money that goes to all of our jurisdictions. We started out as the 3rd state, and now we're in over 29 different jurisdictions. So I'm saying that. I said March of Dimes because I donate to them, but it's the same. I can choose to restrict who it goes to, or I can, but we don't use any state or federal monies that would make this confusing. We're a nonprofit organization that accepts donations that are used to bail people out.
So I just want to be clear. So other state money, people from other donors from other places, money could be used to bail Kentucky people out, or vice versa.
Yes, sir.
Thank you. I'm not making a value judgment today on whether or not that's good or bad. I think there are members of this committee that would feel both ways. I just wanted to clarify because I didn't know. You mentioned the success rate. I've got a couple other questions, but I'm going to let some other members go. Representative Bana.
Thank you very much for your presentation. I have a question. It might be too far in the weeds, and if it is, you can text me or email me later. In terms of recidivism, do you have people that come back to you a second or even a third time to be let out on bail to use your services?
Unfortunately, we've seen people come back through the system for a myriad of reasons. If they have old outstanding warrants in cases, which is why we work with our community partners, ACLU, all these other groups who are working to prevent that, because people are going right back to the communities that got them there. Majority people don't, but some people are caught in poverty due to substance use issues, due to mental health issues, due to many gaps in services that all of our communities see. And if we have had a successful experience with them, meaning their old case, they've come back and they've did everything they did, they honored the release conditions, they are put in queue to be helped. We have had people that we denied services to. We talked about we've paid nearly 4,000 bails. Well, we've actually made that decision in over 12,000, 3 times the amount that we've paid out that we could not say yes to. So there is a decision-making process. But if a person, has a traffic ticket one time or is dealing with another issue, we go on a case-by-case basis, meet them where they at, we interview them to see what those issues are.
Thank you very much.
Thank you.
Senator Wheeler, you want to ask your question now?
Thank you, Mr. Chairman. And you all have touched a little bit where I'm from, the questions I would lead to. But, when I saw you all were on the agenda, I did do a little bit of research. And, I have some concern that you all really aren't looking into some of the people that you all are bailing out. And, you talk about success, but the success that I've seen is that now Louisville is in the top 10 for homicides increases in the United States of America. I mean, I was born there when my dad was in medical school, and, I have a lot of affection towards Louisville. And yet what I've seen over the last 3 years there has just been nothing short of horrific. I saw your sister organization, looks like across the river in Indiana, bailed out 2 defendants, a Travis Lang that was in jail for stabbing a coworker, and yet the bail project, paid his bond, and then he goes out and it says he killed his girlfriend by stabbing her 51 times and dismembered. I think that, maybe the court should have set a bond higher than $1,500. But, when you have prosecutors and judges in these large metropolitan areas being funded by George Soros and other folks that have a goal of putting people back out on the streets, I mean, this is a concern for the safety of these communities. And to me, you all are exacerbating an issue that we're seeing in some of these large cities. I mean, what are your criteria? If somebody stabs somebody, you're going to bail them out? Is that correct?
Do you want to answer part of that?
It's the same as what I said previously. We do look at the full scope. So we're looking at that person's context within the criminal legal system. We're looking at their bail amount, their current and previous history. We're looking at how they've been able to come to court. We're also speaking to them, sitting face to face like this with someone in jail and seeing what supportive services they need. And if we can't meet that, we're not going to bail them out, because we do also care about public safety. And that includes the person that we're sitting across the table from, because they are a member of the public. And so we make these decisions holistically, but we want to meet these folks where they're at. And when we make those decisions, we make them with integrity. We confirm that they have safe places to go. We confirm that there are people that can remind them for court and that we can reach them at. We do a whole myriad of things. We are not just swiping a card and not looking at anything and getting someone out. We do have a process, and that was a point of us coming today, was to explain that we do. And I feel like we've done that. I'm happy to reiterate some of that. But Shamika, if you want to add to that.
As someone that is a gun violence victim, I've been on every side of the courtroom, not just as a defendant. As someone who lives in the West End, who birthed kids in the West End, I've seen a lot of things. And I will tell you, our work is not what's making the crime rise. We have a problem all over our country with poverty, with gaps in services. We all are surviving failed policies. Some of us at different levels, but we all are surviving those. And so one nonprofit that is trying to do work and meet people where they are in the middle of a system where they're supposed to be innocent until proven guilty, at that very moment, we are doing everything we can. We're always readjusting our processes to meet the needs of the community. We keep the community first. We keep the people first. But as I've said before, we don't have the all-seeing eye as a judge do. So if that person got out, if any of us left out and did something, a judge set our bail, they get out, are we going back to those judges? Are we going back to their defense attorneys? Are we going back to the jail that processes the release? Unfortunately, there's elements of this that no special nonprofit can do anything about. And that is something we want to be clear about. I do care about the violence. I've lived through that violence. And I would not have taken this job. I wouldn't be in front of your face if community support with releases did not work. That is how we operate. But yes, people are going back to the very same communities and neighborhoods that they were in before they were incarcerated. But we have a system that's in place that has all kinds of avenues to deal with that, sir. We're not the judge, jury, and executioner. We're meeting people who are often poor and stuck pre-trial and have not been convicted, and we're meeting them at that level. So no, we have to operate as such. And most of you are lawyers, and you understand that.
Most of us aren't.
Oh, well, a great deal of you are.
Thankfully. Senator?
I guess I would just say the communities that you're trying to help, they are also at most risk when these people are let back out, especially ones that have violent history. They're typically going back out into those communities, these communities touched by poverty, and they're the ones that are suffering the most. Is that not correct?
Do you want me to? I'm passionate about this because I live in the communities that we're talking about. And most times when people are incarcerated, those communities are impacted by that person that's incarcerated. That person might take his grandparents to go get medications or walk the children to school. So I see it from a different lens on the communities being impacted by people who are incarcerated. I also know that we have to work with the police, we have to work with corrections and everyone else that is a part of the system when somebody messes up. But ultimately, a person is responsible for what they do in the community. Just like we are all responsible for being here today. If somebody does something, they are to be held responsible, and we don't get in the way of that. If they are convicted, that is one thing. But if they are held, our law says that we need to address them as innocent until proven guilty. Bail was never meant to be a punitive thing to hold people. It was set up to be a condition of release. So once a bail is set, someone higher than us has already made the decision that that person, if they meet these release conditions, can go out. We're not the person making that decision.
Thank you, Mr. Chairman.
Representative Petrie.
Thank you, Mr. Chairman. And these are more detailed questions than policy questions. I'm really not going to get into whether cashless bail is better or worse. But on what your organization does, so you filter and go identify, yes, we're going to assist this individual who's been charged. and supply bail, do you enter into any type of written agreement with them regarding the services that they're supposed to, or you hope that they will undertake with you the things you mentioned earlier? And these are detailed questions, and we'll get through them fast.
So whenever we do interview someone, we do ask questions if we are able to interview them, and if they give us permission to post their bail, we do ask that and we do document that. We work with clients that have court orders to go to treatment at times.
Okay,
And
I'm
we
going
work
to interrupt real quick. My question is there a contractual agreement with a defendant?
No.
Okay.
Do you mind if I speak to that?
You can. It doesn't matter. My next question is going to follow regardless, but you can.
All right. Well, I will. A judge can set going to treatment as a condition of release, something like that. And, even in those cases, it doesn't guarantee that person is going to go there. It goes back to responsibility. If someone elects that they are ready to receive treatment or would like to receive treatment, employment assistance, anything like that, we are going to do our due diligence to reach out to them, to provide those referrals in the community, and do as much as we can to connect them to the many, many resources that I'm thankful that we have in Jefferson County, and then also in the 28 other communities that we have operated in. So where it's not a written contractual agreement, because we, are not social workers for life for the clients that we bail out. We are trying to provide them support and resources to be able to reach a successful conclusion of their case and be able to instill the presumption of innocence so that they can fight their cases and work their cases from the outside.
Which gets me to my next detail question. Do you post it in the name of the defendant, or do you post it on their behalf?
On their behalf. We post
Have you
as
ever
the bail
posted
project.
in their name?
No, it presents another issue. So we operate a revolving bail fund. So the money that we post for a client comes back in our names so that we can put it in the account and it can be used to get someone else out. So one bail can get up to 3 people out as it goes through our revolving bail fund. But if we post it in their name, if the judge has imposed other release conditions or other issues, that can complicate the money coming back to the revolving bail fund.
Yeah, and so if I understood your testimony earlier, about 10% fail in some sense, but 90% succeed with the bail posting. They reappear, do what they're supposed to do, don't have a new charge, don't get revoked, bail revoked, nothing like that. About 10% fail, but 90% succeed. Is that what I heard?
Yeah.
They attend 90% of their court dates, and then there were, some other numbers in there about, going on and having to spend additional time in jail and things like that. Our forfeiture rate when our bail does get revoked is much smaller than that. It's around 4%.
Then I heard something differently, and I'm glad I clarified that. So 90% of the time, the people that you post bail for do what they're supposed to.
Yeah, more than 90% of the
Okay.
time, it usually happens. And then what we've learned, even from Commonwealth Attorney Tom Wine, is that our return rate is better than the administrative release rate. So they stay within 70 to 80%. Ours stays in the 90 percentile. So
Yeah.
administrative release are people who the court has already determined can get out without a bail.
Yeah,
And then our rate,
and I'm
our
going to tell
rate
you,
is
I've
higher.
looked at that data from AOC and from everybody else and done criminal work in the federal and states for close to 24 years now on both sides of the fence. And the numbers are skewed and skewy depending on who you ask for. But what I'm getting at is this: I'm not sure what the issue is. So there's nothing that prevents currently, no bill passed, I understand, but there's no issue right now. Gather your money up. Let's just say you're a church sitting there. Gather your money up. Post the bail in the name of the defendant. Oh, but now that offers another layer. You've got to make sure that 90% compliance is more toward 100%. When you don't have any, part of the reason people put cash bail out is to have accountability. There's something they might lose if they don't do what they're supposed to do. So with a 501c3 or a church or anybody else that just posts it in their name, then if that defendant does something wrong and violates that bond condition, then it can be taken as a punishment to make sure that everybody else follows the rules and that person does when the next bond is set. So just post it in the name of the defendant and you don't have any issue at all. It puts a little more burden on your filtering process to make sure who you're posting money on actually will do what they're supposed to, but it actually helps all of us in the public policy sphere. It helps the judges because they've already set the bond amount. They've used their best discretion and done that. They really don't. I can't recall a time in my experience of when they say, a church can't post that, so-and-so can't post that. Post the bail, here's the dollar figure. Y'all can do that already. We don't even have to get into a cashless bill and bail discussion or anything else. Post it in the defendant's name. There's great accountability for that. If you offer services to them, you'll get your money back. If they do what they're supposed to, you get your money back, and we're all better off for it. Thank you, Mr. Chairman.
I couldn't say it any better myself, Representative. Senator Berg.
I do not come from the world of the justice system. And when I was elected and came up here, I thought, wow, our healthcare system needs a lot of work. It has been a major enlightenment for me to find out that actually I think our judicial system is in worse straits, has actually suffered more through COVID. And when we're talking about average pre-trial incarcerations, you're talking about people that you're keeping in prison. They have not yet had a day in court. They have not yet been found guilty. They are being taken away from their families, from their income, from their communities, basically waiting for a trial when we know that the backlog is so extensive that some of these people are literally waiting in jail for months and months over non-violent offenses, things that do not pose a significant risk to the community. I was really unaware of this. It is a huge problem. I agree with you that ideally we would work you out of a job, that the answer is to figure out how do we reform, how do we manage our bail system in such a way that it is not entirely dependent on your income, which is grossly, grossly unfair. So I just want to say thank you for your work. Thank you for sharing your personal experiences with us. I know that's not easy, and it does matter. I have another comment, Mr. Chair. And it's not necessarily going to be brief. I try to speak succinctly. A comment was made that upset me. Some of you may have noticed that I slapped my hand on the table. I was raised by a dad who used to do that when he got angry. That's what he did. I am not going to address this comment to a specific person in the room, but I would like to share with people that there is a very strong anti-Semitic meme associated with the name George Soros that I do not appreciate being brought up in this room. I am to the point where I am willing to call it out when I see it and call it out when I hear it. This was not done in the House when it should have been, and I am speaking up. I am offended by the use of that meme, and I hope it does not happen again in this building. Thank you.
Senator, I appreciate it. I don't think that's the spirit in which those comments were given. I think it was. I think there was a criticism about people backing any given particular initiative, policy initiative, in this case, one with which the member disagreed with. Senator Carroll.
Thank you, Mr. Chairman. Just a couple quick questions. Do you all have a policy where you contact or consider the victim in any of these crimes before you post bail?
If there is a victim involved in the allegation, we do confirm with the folks that we are posting for and their supportive contacts that they are not going back into a living situation that would violate an EPO or a protection order. So we do have that process in place.
Do you consider what the victim has been through?
We don't contact the victim themselves, but we do take everything into consideration. And if we cannot support that person given the conditions of release, then we won't move forward with that bail.
Okay. And as far as cooperation with law enforcement, if they come to you looking for an individual that you posted bond, Do you have a policy to assist or not assist law enforcement in locating that person?
I don't know if I've ever been in that situation. We work with our public defenders, to provide court reminders and court support for our clients, but I've never personally had a member of law enforcement come knocking on my door for one of my clients.
Okay. And finally, liability. Have you all been exposed to any liability for your efforts to assist individuals in getting out of jail and they offend while they're out? Has anyone filed suit against you for your actions?
We are not at liberty to discuss that, but thank you for your question.
Okay, I'm not asking for any particular case. I'm just asking yes or no.
Not at liberty to discuss that, but thank you for your question.
Okay.
Be happy to
Okay.
have someone from our organization follow up if you'd like.
Okay, thank you. Thank you, Mr. Chairman.
Representative Bratcher.
Just a few short info questions. So you do talk to the clients? You call them clients in your paperwork. Do you talk to the clients before they're released or before? And do you have a checklist of what you go over just briefly?
We have an intake and needs assessment for that process when we interview them. So we want to gather contact information, living situations, as well as supportive contacts, mom, friend, girlfriend. And then that's also where we assess for any of their identified needs to connect them with voluntary resources.
When do you turn clients down?
Yes, sir. As Shamika mentioned, we have received nearly 12,000 referrals. We've only posted almost 4,000. So we do have to say no. And whether that's, at whatever point, we do have to say no often.
And two more short ones. Can you tell how much money you average in your accounts, or is that something you don't want to disclose? How much do you raise?
Well, I don't have those numbers. It's ongoing. Like I said, anybody that donates online, it goes directly to paying bills, not our operation costs. Like I said, we've invested. We pull from a pot of money to pay the bills. So today, Carrie is the operation manager. The team says we need $14,000 to pay bills. We put in that request to our CFO, and then that money is transferred to the account. There's no amount of money just sitting in the account at any given time. It's only request of what we need to pay those bills for that day. Any money that is refunded, which is, I appreciate Representative Petrie, so that we can make sure that people come back and that the money comes back into the revolving bail fund. When we get those monies returned, we put it right into the account, and then that money is taken out of that account and put back into the pot of money.
And the last question is, you seem to seek, I wouldn't even hardly know you exist if it wasn't for your high-profile cases. So do you seek attention and for the high-profile cases? Do you really go for those that might increase your donations or whatnot?
No, sir, that's not how we operate. Those high-profile cases come up because there's all kinds of situations that happen when you're dealing with people who are struggling with poverty. Those things happen. Most of our clients don't become high-profile cases. Every now and again that happens, but no, we don't exploit that. We don't exploit our clients. We have had clients that have come here with us to testify about our services and how we've been able to help them, but that is on when they identify that's what they want to do. And to also let you all know that many clients are appreciative of our work, and they consider coming back to court, making sure that the system works is a way of paying it forward. When I interview clients at the jail, I can't tell you how motivated they are when I tell them, yes, the bail we pay for you once your case is done will be used to pay for more people. That has been the most motivating factor for anybody. So even at the worst time of their life, they're in a jail cell, they're still caring about paying it forward.
There was an assassination attempt on a mayor candidate in Louisville. Was it you guys the ones was that your client that you bailed out?
No, sir.
That wasn't you guys?
No. I wish you were with me on my campaign trail so to tell people.
Okay.
That wasn't me. That wasn't our organization. It would have been a conflict of interest. But like I said, like we all know, that bail was set. That person had a right to bail. It was paid, but it was not our organization.
All right. Thank you.
Thank you.
We've got one last that we can get to because I want to have Representative Blanton be able to respond here and speak. Senator Neal, you get the last question here before Representative Blanton. And while you're gearing up and turning your mic on, does the Kentucky branch of the Bail Project file a separate 990? IRS Form 990? Does the Kentucky Bail Project, does it file a separate 990 than the parent organization does?
Well, we don't handle that part, but we had to be set up as an entity, as a nonprofit entity in our state. So I want to
So I
tell
would
you
say you
yes, but I want to make sure that we get back to you with more accurate information.
If you can email us a copy of that, that'd be great. Just out of curiosity, because members have asked questions. Senator Neal, last question before Representative Blanton.
Actually, I had several long questions, Mr. Chairman, but I'm not going to go down that road. And it may have been answered, but it did pique my interest, which gets to the crux of the matter for me. Did you say that the pretrial release programs track record of those returning to court is inferior to the returns of this program in terms of people coming back?
They're one of our stakeholders and community partners. I wouldn't call it inferior, but there are clerical mistakes that are made. There are issues with return. But the main point is when I have Commonwealth Attorney Tom Wine before a presentation, we're in the same presentation. He gives his presentation and he says that the Bail Project has a bigger return rate. He did help bring the Bail Project to Kentucky, but he noted that our return rate was better than the administrative release, meaning that the people who get out, like you said, through the court process, they do come back to court. Ours come back to court more.
Okay, I'm not going to do another question, Mr. Chairman, but I do want to say what I've heard here today has been an education for me. I'm very impressed by the way you've responded to the questions. Some of these questions that I wouldn't answer if I was on the other side, but most of them I would, and I thought they were revealing for them to ask the question and for you to respond the way you have, and I congratulate you on that. But also I want to say that I think it's important to understand there is no perfection in the criminal justice system. If we're looking for the exception of what goes wrong and using it as a basis to extrapolate policy, then we're making a mistake. If we're looking at what is happening that brings about an overall good, then we don't want to throw out the baby with the bathwater. And I think it's very important for us to understand that does not mean that there can't be a circumstance that we can get our fingers around that does not undermine what I perceive as a very positive piece. We have a system, and all systems have challenges, no matter what you do. And even when you try to resolve those challenges with your best intentions, you're going to have challenges that you have to address. So I've picked up some of the tone here in some of these questions, kind of disconcerting to me. I didn't understand that. I congratulate you on your effort and hope that we do have a collaborative relationship that's developed. I pledge myself to that. I trust a number of my colleagues will also do that and keep up the good work.
Thank you.
Thank you, Mr. Chairman.
Yes, sir. Representative Blanton.
Thank you, Mr. Chairman. I will try to be as brief as possible. Probably not a good day for me to be on this subject. Been going through a lot the last week and going through a lot of emotions right now, so I will try to keep this very brief. Work during the session with you ladies, very amicable work, I would say. I felt like I come up with something that was accomplished a little bit of what we were both trying to do. And it's really not your all's organization that we've been given the problem from, right? We talked about this. There's other entities. We've heard very compelling stories, and I'm with you. I told you in my region of the state, it's not so much the race issue, but more of the poverty issue of people getting out. And so I get that, and I get that there needs to be help for those folks, but we also have to find a balance of protection for the general population. So in doing so, I came up with what I thought was a reasonable cap, if you want to call it, so that you all can still do what you're trying to accomplish, because we know the higher the bond, generally the more severe the offense. And so was looking at trying to do something there. And you all are falling under what unfortunately, probably every one of us in this room with something in their lives fall under. Laws are passed, rules or regulations are passed that we abide by or are forced to abide by because somebody else acted improperly, right? And these things get passed and it impacts us. And sort of the thing here, because as we talk about sympathetic things, I could bring at least 3 families in here today if I wanted to that could testify to this committee how that they lost their loved one from someone that was bailed out by one of these groups that would have been incarcerated, including families of teenagers who were innocent victims, and they lost their lives because they were bailed out. And so, you know, I sought to find a balance to where you could accomplish what you were doing, and that's to help those that don't have the financial means and aren't a risk, because there's 2 reasons that you have to arrest somebody that's committed a crime. You put them in, and the bond is set, and that is 1, to assure they show up for court, and 2, to protect the community, right? And that's what we're trying to do. So, but unfortunately, I think some of us live in a utopia. One thing I will disagree respectfully with you on is when you made the comment about mass incarceration and how this helps with it causes or is a correlation of mass incarceration. And the fact of the matter is, mass incarceration has nothing to do with whether you all can bail somebody out or whether you can't. Mass incarceration has to do with the fact people are committing crimes and they're getting caught committing crimes. That's what causes mass incarcerations. And I know that there's been times that I've taken people out of communities and people in that community thank me for getting that individual out of that community because they're such a menace, they're so fearful, they live in a state of fear, and then all of a sudden some group that they don't even know comes and pays their bail, and they go right back into that group, into that community that thought they were getting some relief for a little bit so they can maybe sleep at night. So we've tend, in this utopia world that we've created, and by the way, this is not new, it's just new to coming to Kentucky. We've seen it across this nation take place, and what we're seeing from it now is crime rates are skyrocketing, businesses are moving out, the populace are moving out, and now we hear that although maybe not 100%, at least to some degree, we're using people from San Francisco, from Portland, from Chicago, from New York's money, who obviously their criminal justice reforms are failing their citizenry. Now we're using their money in Kentucky to bail people out and send us down that same path. And so, you know, I come and I get where you're looking towards, but I'm looking at the victims. We have totally, as a society, we've painted a picture of people who commit crimes. Okay, they commit crimes. They victimize people. We are forgetting about the victims. We're focusing totally on the criminals, and we're forgetting about those people that are hurting. They've lost loved ones. They've lost property. They've become addicted because of it, and we're focusing all on them. So I tried to give something that would be workable for everybody, and apparently that's not. I mean, I could have easily, as far as me, I would have been just as well say, okay, let's make this totally legal. We don't need this in Kentucky. But I said, no, let's help those that are poverty stricken. You know, if they're below that 5,000 mark, chances are they're not that big of a threat to society, but yet they can't come up with the funds. So, okay, let's set something in place. So you guys, the ones I feel like that is operating in sincerity and trying to do the right thing, so you can still be active, but yet those groups that did, and I know who let the attempted assassin out, who got him out. I know the group that done that. That wasn't you all. But nevertheless, when they do that, it forces us as policymakers to set things in place to prevent those things from happening. So with that being said, I've told Mr. Babbage I continue to be willing to work on this, to come to something that helps what you're trying to accomplish, but it also helps protect the citizens of the Commonwealth at the same time. And I think we can get there together. I try to be more like, Henry Clay. I try to be the great compromiser and work on something we can come together on, where we all come out with a little something that is helpful to our cause and what we're trying to accomplish. But I just warn all of us, whether you're on this committee, whether you're in this room, or whether you are watching at home on KET, Kentucky, let's be cautious. Let's not go down this road of getting under the guise of feel-good things, of making us feel better about ourselves, creating a society where we create more crimes. Because when you have more crimes, you have more victims. We have more people losing their lives. We have to protect the citizens of this Commonwealth. That's part of our responsibility as legislators to do. So with that, I don't have any questions, Mr. Chairman. I thank you for your time and indulgence. Thank you. Thank you, ladies, for being here.
Thank you, Representative Blanton.
Thank you. Thank you, ladies. I appreciate it. We do have one more last question from Senator Turner.
Thank you, Mr. Chairman. I'd like to thank these ladies for being here, and I would like to state that I look forward to working with my good friend over there trying to get this. Mine's more of a statement since we've heard all this stuff. I think we better stop and think about our Constitution. Innocent until proven guilty. In the 42 years I've practiced, I've seen just what these ladies have talked about and helped. Many person had a guy that was, when you plead self-defense, the first thing is, though, the bonds are never, 90% of the time, are never put in the defendant's name. It's some family member or somebody else. That's not in the family's name. It's not in the defendant's name. So the gentleman over there needs to, I bet he gets the statistics on that. But I went through a fellow that pled not guilty he had 4 trials. He was in the jail for 2 years, and every time we'd get a hung jury or something happened, I'd ask the judge for bond, and he'd say, no, I believe he's guilty. And the judge was my friend, but when the jury came back and said he was not guilty, look at what a life he lost. So bonding is a purpose, and once the judge makes the determination, it's not behooves us, whether it's what, like you all said or anybody says, anybody can go post that bond. And I have people that's done that in the 42 years that I've practiced. The committing of crimes is one thing versus bonding is another. And when you get somebody that's shoplifting because they've got 2 different colored socks on in a store in Lexington and they get put in jail, which happened, and it was primarily because she was from a foreign country, I can go down the list of kids that's in college. I've had to sue Walmart, Kmart, Kroger's. I can go down that list for wrongfully charging people, but they were put in jail and held, losing jobs. So I'll give a book if everybody needs to hear that. But if those people had the ability to got out on bond immediately where they could retain an attorney, now I'll help them out, because I come up poor from a family of 11 children, and my job is 42 years of practicing law, and I did a couple of years of adjunct professorship at Chase teaching a little bit. So we need to think about this through. We're getting excited in America about all these crimes, but we got to stop and say Constitution comes first. That's all I'll say, Mr. Chairman. Thank you.
Thank you. Representative Cantrell, you actually have the last word here. The last question, I beg of you, please.
It's not really a question, but it
Oh,
will be
you're
short. It will
killing
be.
me.
It will be.
Not just you, all of you. Killing me. I whispered over here to the chairman. I said I had a rule during session that I'm gonna, if you're not asking a question, I'm not gonna call on you. And I am this close, y'all. Go ahead,
I
please.
can email it to you.
No. It's all right. You were on the list. I didn't catch that. Or go ahead.
Well, thank you. And my comment really goes along really well with part of what Representative Blanton said. And I've been here for these conversations up until now. I'm not going to be here next year. So take this in the spirit with which it's intended, and it's intended in a spirit of compromise. I've listened to both sides every time this issue has been debated. And what I'll say is, if there is a will of the legislature next year to limit these types of organizations, what I think I've heard a lot in these conversations is, and what I've seen in the legislation is, I think maybe we're taking the wrong approach here and limiting it based on money. I keep hearing people saying that they have, because our system is incredibly flawed, there's a lot of flaws in perpetuating a system of cash bail and limiting the contribution of a community bail organization based on money as well. And what, having lived in the community that ignited this issue a few months ago, what I am seeing is an outcry from the community about the offense that's committed. And that we should be centering on the offense, that there are maybe certain offenses that are so abhorrent to the community that community bail funds should be maybe limited in those situations. The community bail organization would be on notice of which offenses they could participate in and help release offenders in that situation. And then I think we as legislators could sleep at night knowing that maybe we're just reverting back to our old system in terms of certain offenses, that if you have money, you get out, and if you don't, you have to look toward other means. And I think when Representative Blanton was talking about that he's willing to continue working on this issue, I think that should be a part of the conversation, because I think in the last part of the legislation that we considered, I think domestic violence was a part of that, along with the financial restrictions. So we know that there are certain offenses that we don't want people to be able to collect money to be able to get out as easily as possible. And I don't want to add a lot of extra complexity to this conversation, because I know that we probably wouldn't even all agree on the offenses. But I do think that that's an important part of the conversation, that's where really the community outcry is coming from, that we know we lived in a flawed system, but let's not perpetuate it. So I'll just leave it at that, take it in the spirit with which it's offered, and I hope you'll consider it going forward.
Chairman, can I make one statement?
No, ma'am, I'm sorry.
All right, okay. I'll email you.
That'd be great.
Okay.
I'm going to ask you all to step down and have our last panel up here, Senator Reginald Thomas
Thank you.
and his guests with Bluegrass elder law, regarding adult guardianship. And that's going to finish up our meeting today. I appreciate, Senator, your great patience as we've worked through these other items on the agenda. I thought charitable bail would be interesting and attract some attention and questions. I always underestimate. You have the floor, Senator.
Chairman Westerfield and Chairman Massey, it's good to see you gentlemen once again. I'm here because I think it's time that our legislature modernize our guardianship statute. That's why I'm here today. Our guardianship statute needs to be modernized, and I'd like to see that enacted in 2023. I'm going to begin by saying this idea came to me when I was watching a movie. A movie gave me this start. There's a movie called I Care a Lot. And if you watch that movie, it talks about the abuses that can occur with regard to guardianship in elder care situations. So after watching that movie, I said, well, I'm going to look at our guardianship statute. And so I did. I went to KR's chapter 387 and started looking at it. And as fate would have it, about 3 or 4 days after I started looking at chapter 387, I got a call from Ms. Fennell and several other practitioners and advocates and leaders in this elder care area saying, I want to talk to you. I mean, it was just really coincidental. So we began meeting in September and looking at the statute and began revising it. And by the time session began in January 22, I had a bill that I introduced. It's Senate Bill 132. Okay, and that's the bill. I don't know if you have it before you, but if you do, that's the bill that I like to see enacted that deals with changes in our guardianship statute. And there are 8 I want to point out to you. I realize that the hour is late. And I'm like you, I've got other things I've got to be doing too, but there are 8 changes that I want to make, and then I'm going to turn the floor over to my esteemed colleague here, Ms. Katie Fennell, who'll take over the rest of the way. the statute makes 8 significant changes. Number one, it changes the term ward to protected person. And ward has become sort of an outmoded, has sort of a negative connotation in our world today. And what we're talking about, people who need to be protected, elderly people, people with younger people with disabilities. And so to give them some sort of dignity, we've changed the term from ward to protected persons. That's the first change. Number two, we separate out the duties of the respondent's attorney, the respondent being the person who is the protected person. Okay, we change out that the respondent's attorney has separate duties from the duties of a guardian ad litem. Now, most of you are familiar with what a guardian ad litem does, and what this new law does, it keeps the guardian ad litem, but more as someone who's as an advisor to the court, as opposed to being an attorney for the respondent or protected person. The protected person has their own attorney, and the guardian ad litem is still in the court as an advisor. Number three, if a curator has been established, and I'm going to let Katie, I've obviously prepared for this, but I'm going to let Katie talk more about the difference between a curator, a guardian, and a conservator. But if a curator's been established, then that can be a location for a place of venue. Number four, the current law talks about next of kin. And again, we're all, familiar with that term in law school. We were taught about next of kin in law school. But again, I think we need to come to the 21st century. And so what we've done here is we've deleted any reference to next of kin. That's no longer in this proposed bill. It talks about not contacting the spouse, the grandchildren, the parents, or curator. Obviously, those people who have a close familial or close relationship with the protected person. Okay. Number five, the new law requires the establishment of what we call an interdisciplinary evaluation report. An interdisciplinary evaluation report, Chairman Massey. And what that does is compiled by 3 individuals. In other words, if you think about the current eminent domain law, where if a government entity or agency wants to enact eminent domain, there's 3 appraisers. Well, we've taken that same concept and apply it here. So that, again, we want to give the court as much familiarity and as much information as knowledge as possible to make a thorough and hopefully correct determination about what to do with this protected person. Right? And so the court will receive this interdisciplinary evaluation report from 3 independent people who the court appoints to help the court and guide the court in making a decision. Point number 6, we say that this petition is going to be heard expeditiously. Now, Ms. Fennell will tell you that sometimes here in Kentucky, unfortunately, these matters drag on for a year. Okay, and Senator Carroll, we want to speed this up. We want to get this done, obviously thoroughly but quickly, so that the protected person can have the guidance that they need and be able to move on. Okay. Number 7. Okay. We give the court flexibility. Okay, and we've heard a lot about that today. We give the court flexibility in terms of what should be the proper ultimate outcome with regard to the person who is in court, who is the protected person. Okay, we state in this legislation that if the court thinks less restrictive alternatives are better, a power of attorney or curator, that they can make that decision as opposed to giving the person a full, court-ordered guardian or conservator. In other words, if a less restrictive alternative is better, then the court can do that. Okay. And then point number 8, and this is my favorite point. For me, I say the best for last. If an emergency guardianship is enacted, Senator Neal, we limit it to just 60 days. The abuses come in where you have this so-called emergency that's created. And again, this movie that I point out highlights this. And this emergency continues to go on forever and ever. I mean, the emergency can extend on for a year or more. And that's where you get real abuse here. Sometimes these petitions have ulterior, not so nice motives. So the bill limits the emergency to 60 days And if they can establish to the court, they get a one-time extension for 60 days. But after 120 days, this is over. This is over. Okay. And then you go through you have to go back and determine, again, where this person goes through the normal process where this guardianship can continue. Okay, those are my 8 points that I think need to be changed and is part of Senate Bill 132. Katie, I'm going to turn it over to you because, again, you're the expert here, and you can tell the committee what you think about Senate Bill 132 and why it should become law.
We cannot. Might make sure that.
Push the button.
There you go.
Okay. Good morning, everyone, or probably good afternoon at this point. Thank you very much for having me here today. So my name is Katie Fennell. I'm one of the partners at Bluegrass Elder Law in Lexington. And one of the big questions is, what is elder law? So estate planning, probate, guardianship, special needs planning, long-term care planning. So this is right up my alley. Senator Thomas wanted me to mention I'm a proud Chase graduate. I also have a legal master's in estate planning and elder law. Bring on the lawyer jokes. We get the doctorate first, then the master's. I know. I'm in a room of very smart people, and you're reading this legislation.
Now, there's your first mistake.
And if you'll indulge me, I will be very respectful of your time. I wanted to briefly kind of explain the guardianship process because even the attorneys in the room may have never sat through a guardianship. So a guardianship hearing is confidential, meaning only parties to the case are allowed in the courtroom. So even if you are an attorney, if this is not your area of law, it might not be anything that you have experienced. And so the big thing in this legislation is due process for the potential protected person. So changing the term ward, which kind of has a negative connotation, to protective person is difficult for me too, because I'm used to saying the word ward. So I'm trying my best to remind myself protected person. It also helps me explain the process to others. Most people go into guardianship out of love. Maybe somebody has dementia, somebody has some health issue, maybe you have a special needs child. I love them. They need help. I want to go through this process so I can have the power given to me by the court to help them. There's also the predatory version of this, is that I want to get power over someone. I want access to their money. I want it for control. So when I, as an attorney, am explaining this to someone, I would much prefer to use the word protected person than ward, because I think it helps explain the intention of the whole guardianship process. So the guardianship process has two different ways to start. There are two different guardianship types of cases. There's an emergency guardianship and a regular guardianship. When I think emergency guardianship, I think somebody has had a health issue, all of a sudden they're in the hospital, they are not able to make decisions. It is an emergency. And the process moves a lot faster, so that emergency guardian can help fix or handle the emergency. Sometimes the emergency ends. Your medical crisis is over, you've regained consciousness, you're perfectly fine to act yourself. The guardianship should be dismissed because you are no longer somebody needing that protection. The more common type is a regular guardianship. I think the easiest way to explain that is maybe a special needs child is turning 18 and all of a sudden you don't have that parental relationship, they are legally an adult. We're looking at the guardianship process to help them continue on past their 18th birthday. So that's not an emergency. That's something you see coming. A lot of times, the emergency guardianship turns into the full guardianship. You know, we have that medical emergency, we file emergency guardianship, and we proceed to full guardianship because that person never regains the ability to make decisions. A lot of what this proposed legislation does is protect the rights of that protected person. We talked earlier about guilty until, or innocent until proven guilty. We're talking about competent until determined incompetent. And that's where the guardian ad litem and respondent's attorney comes in. When you file a guardianship petition, it looks like a criminal charge on the paperwork. It is the Commonwealth versus somebody, the supposed protected person. That person should have a right to defend themselves. Maybe, you know, they can have an objection. They don't think they should be under guardianship. They think they're should be able to make their own decisions. The court appoints a guardian ad litem, which is also known as the friend of the court, and their job is more like a best interests attorney. They're looking at the whole situation and they're reporting back to the court. They are not meant to be the respondent's attorney. They are not meant to defend that person because those might be different situations. If somebody files guardianship for me, I might greatly disagree that I should have a guardian. So my attorney should argue for me that I do not need a guardian. Is that what the guardian ad litem would say? I don't know, but I have the right to hire my own counsel. So currently in Kentucky, that legislation is not clear. We have a lot of judges say, well, you can't hire your own attorney. You already have a guardian ad litem.
Are you aware of cases where judges have prohibited someone from?
Absolutely.
Really?
Absolutely.
That is unbelievable.
Absolutely.
Okay.
Mm-hmm.
And what are you, and Senator, you mentioned the GAL role having a different role, I'm curious, where's their legal duty? To whom is their legal duty? Is it to the court that you're recommending, or is it to the respondent or the person to be protected by the guardianship?
Chairman Westfield, let me answer your question directly. Under the statute, under the bill that I propose, the new statute would have that duty. The guardian ad litem's duty would be to the court. Their duty would not be to the protected person, and of course their duty would not be to the Commonwealth as well. Their legal representation, if you want to characterize it as such, would be to the court.
Mm-hmm.
Okay, thank you.
I think of it similar in, say, a foster care case. The guardian ad litem represents the child to the best interests of the child. It's the same. Right. It's just like an adult, just for an adult.
Except in that particular case, I think the child is the client. They're filing a report to the court.
The guardian,
but it's based on what's in the best interest of that client. That sounds different from what's being proposed. I'm not saying that's good or bad. I'm just, we've got an understanding of what a GAL is, and I'm curious how that might change.
In adult guardianship, they don't generally file a report. They usually appear at the hearing and testify. But it would be the same. You know, I have met the proposed protective person. I believe it would be in their best interests to...
Would the best interest standards still apply?
Yes.
Okay.
Mm-hmm.
Thank you. Sorry to interrupt.
Curatorship. So the states...
And we have, by the way, about 5 minutes before members have to be at another committee meeting.
I can do it. So guardian is of the person. You're taking care of the specific person, medical decisions. Conservator is over the money. A lot of times it's the same person. Curatorship is different. Curatorship is voluntary. It's usually heard through the probate court. And the petitioner says, you know what, I am no longer comfortable handling my finances. I would like my loved one or whoever to do it. It is uncommon. We're usually looking for the least restrictive option. No one wants to go to guardianship court. In most cases, if somebody has a solid, well-drafted power of attorney document so that they have someone that can help them, you don't have to go to guardianship court.
In your experience, are POAs, even if they're durable, are they recognized or relied upon by third parties as easily or as consistently as perhaps a court order is? In my experience, no matter how well drafted a durable POA is, there are some third parties who will take it and trust it, and there are other third parties that are, particularly healthcare providers, that are very reluctant to take that.
The difference is the power of attorney cannot make you do anything.
That's true.
The guardian can.
Sure.
So, a power of attorney can suggest to their person that they follow the medical advice, but they can't make you.
Yeah.
And so we do occasionally have somebody with a power of attorney that ends up in guardianship court.
Got it.
And my example, just because I deal with elderly, is maybe dementia, but the combative dementia, where you're at risk to yourself or others if you're not doing the things you're told to do or taking your medication. Let's see. A big one for me, I'm going to skip to the end, is addressing the needs of the spouse. So we are in a climate where we have a lot of second marriages. And so a lot of times we end up in court because it is the children from the first marriage filing and the spouse is the second marriage. And we find that judges don't know where the line is because there isn't one regarding supporting the spouse. So we hear a lot, well, that needs to be determined in family court. Well, they don't want to get divorced. We're just looking at the money. So if historically the protected person paid half the rent, half the mortgage, it seems reasonable that they should continue to do so. Things like that. The bigger thing on my end is for Medicaid planning purposes, and this is a whole other bear. Long-term care Medicaid is what pays for skilled nursing care. When I talk about asset preservation, I'm not talking about the person in the nursing home. They have 24/7 care, a roof over their head, 3 meals a day. They might not be happy being in the nursing home, but they are being taken care of. I'm talking about the spouse at home, giving us the opportunity to use the long-term care Medicaid rules to preserve some assets for the spouse at home. Because if they spend all of the assets for the spouse in the nursing home, it leaves the one at home indigent.
So Medicaid already allows this. You're just saying
Right.
Okay.
We just have to have court permission in order to utilize some of those tools, and judges aren't comfortable doing it because nowhere does it expressly say that they can.
Well, this has been really fascinating, at least for the I'll speak for myself. This is not a practice area that I'm in at all much ever. I'm familiar with it. I've been a guardian ad litem in DNA dockets for a long time. But adult guardianship is not something I've done much on. I'm really surprised that there have been judges that have said you can't have counsel present. We've seen that in victims' cases pre-Marcy's Law, and that's understandable. There's no basis in statute, at least not a strong basis for the right to counsel in statute before that constitutional amendment was adopted. But that really surprises me that you've seen that happen here in Kentucky. But then the other factors that you all mentioned, are all the things in the bill that you filed, Senator?
Yes, Chairman Westerfield, they are there, and that's why I'm such a strong advocate for having this legislation adopted in 2023, because it's time now that we update this guardianship law. And Senator Westerfield, you know how I am. I believe that your rights do not age out once you get to be 65, 70, or 75. I mean, you don't lose your due process rights to protection of property or liberty. And this new statute or the amended statute would provide for that.
Thank you very much. I think there are some really reasonable changes here in your proposal. I'm going to let Representative Vanna have the last question of the day.
Thank you very much for this. I'm just curious, have you shown this to county attorneys? Have you had any feedback from people that have to deal with this like all the time?
So I have talked to private counsel. So there are several other attorneys that assisted on this. They would all love to be here today. Several are on planned vacations. One is actually in guardianship court. I have not spoken. I'm in Fayette County, and our Commonwealth attorney that handles these cases is fantastic, but she is overloaded. But I'd be happy to do so.
Thank you, Representative. Folks, I know there were some other questions frankly, on each one of these panels that people had that we needed to cut loose so that we could get done 2 minutes late. So I apologize for holding you over. I know Natural Resources started a couple minutes ago.